Okay, well, let's start on this second session. Thanks to Geraint for the first session on some really interesting case law and commentary on 54 Act stuff, which is always important. This is the second session. It's a relatively short presentation. It's about undue influence in mortgage cases. And I'll introduce the next speaker when I finish. But just bear with me. I'll try and share my slides with you. I guess the clue is in the title. It's really all about who the borrowing is for. I think many of you may have seen recently my involvement in our King's probate seminar. And I gave some talk there about undue influence in mortgage cases. This is undue influence in probate cases, sorry. This is about mortgage cases. The content's twofold, I guess. I'm going to give some introductory comment on mortgage cases. The law is quite difficult, unfortunately. It's quite complicated, so I'll try and give a bit of a dot-to-dot guide to introducers. I'll then start on the recent Court of Appeal decision, One Savings Bank and Waller Edwards. Quite an interesting decision. It's been widely reported, and in fact, I noticed even, I think yesterday, I downloaded an article by a London city firm. It comments generally about the case, but I think it misses some of the potential consequences for litigators. So I'll try and pick up on those at the end. Contents, I guess, are mainly aimed at lenders, those acting for lenders, also litigators. And I think in this category, I put down those who are acting mainly for wives, and I'll talk about wives in a second, what I mean by that. Those who are going to be challenging securities because of undue influence. It's possibly also aimed at transactional lawyers, those who are required by lenders to give advice. As I mentioned briefly, I've talked recently about undue influence in probate cases. Just take care with this. The two principles, the two doctrines are very different. In many respects, undue influence in probate cases, I guess, is a little bit more straightforward. For the best summary, just have a look at the recent Court of Appeal decision, Rea and Rea. It's actually an appeal from Judge Hodge. It's quite an illuminating review of the burden and standard of proof, some red flags, the issues that are required. But undue influence in mortgage cases, regrettably, I think is very much more complicated. And if, like me, you find this quite difficult, don't worry. I think most practitioners do. And there's quite a lot of law, practice and procedure to work through. The principles essentially revolve around three main cases. Barclays Bank and O'Brien, CIBC Mortgages and Pitt, and of course the Royal Bank of Scotland and Ettridge case. I have a particular attachment to this. I was junior counsel in the Pitt case in the House of Lords way back in 1993. So I've sort of followed through undue influence, certainly in mortgage litigation, for a long time. So some introductory comments just to try and set the scene on undue influence in mortgage cases. We're usually, of course, concerned with three main parties, a lender, a husband and a wife. And I've quite deliberately put an asterisk against the wife there because, as Lord Nichols mentioned in the Ettridge case, the position is, and I'm quoting, likewise, if the husband stands surety for his wife's debts. Similarly, in the case of unmarried couples, whether heterosexual or homosexual, where the bank is aware of the relationship, cohabitation is not essential. It's very much easier for us litigators and commentators to use a sort of husband and wife analysis. So that's what I'll use for this presentation. But the equitable doctrine has to reflect that, the three-party situation. It recognises there are different types of undue influence, actual and presumed. It also has to recognise how to attribute liability to a lender. And it does that by means of notice, whether actual, imputed or constructive. Most of the cases, of course, the O'Brien, the Pitt, the Ettridge line of cases really concentrate on constructive notice and how that's attached back to a lender. So the equitable doctrine then distinguishes between two main types of case, those cases in which wife stands surety for husband's borrowing. And what I mean by that, standing surety, wife provides a mortgage to secure husband's borrowings, and it can typically be a joint mortgage. She's securing her interest for the husband's borrowings. That's the O'Brien type of case. And also those cases in which wife is a joint borrower with husband, that's the more traditional CIBC and PIT type of case. And of course, if you think about it, that covers most of our traditional joint borrowing, where husband and wife may buy a house together with a standard joint mortgage. So the policy of the law has to be quite different in dealing with those two different situations. Significantly, and this is quite an important point, which category it is, which case it is, has to be considered from the lender's point of view. And that's really important. It's based largely on what information the lender's given. And that's usually in the mortgage application form. It may come through other sources too. So in the O'Brien type of case, again, that's where husbands borrow, wife is surety. And the law recognises there's a risk that wife's consent may have been procured by undue influence, and that the lender may take with constructive notice of it. So the policy of the law there is to require the lender to take steps to ensure that wife is independently advised. And that's in accordance with the Ettridge guidelines. Now, it would take me a long time to talk through the Ettridge guidelines. The case note itself is lengthy, but the key principles are set out in the leading opinion of Lord Nichols. I just emphasise one point for practitioners. The mere failure to comply with the Ettridge guidelines isn't by itself a cause of action. It will mean that if wife can prove undue influence, the lender will take constructive notice of it. Again, I stress that point. I do frequently get instructions from solicitors saying that they have a client in a situation of a wife who wasn't given independent legal advice. Could I please settle proceedings to set aside the mortgage? Well, that by itself won't do. You require proof of undue influence as well. In the PIT type of case, on the other hand, the policy of the law is not to require the lender to take any steps at all. Now, I put a ... there for a reason, and it's this. The policy of the law is not to require the lender to take any steps at all unless it's aware that the loan is actually being made for husband's benefit. Now, that's the kind of loophole that's left by the O'Brien, Pitt and the Ettridge line of cases. And it's that bit with which we're concerned, where there's a joint application, but the lender's nonetheless aware that some element of the loan is for husband's benefit. And it raised the question, is there a third hybrid category of case? In other words, a sort of intermediary category of case between O'Brien and Pitt, which may require the lender to take particular steps. That's what Waller-Edwards was all about. So let's turn and have a quick look at the case. I'll talk through the facts first, and I simplified the facts quite considerably. Miss Waller-Edwards owned her own property outright. She formed a relationship with B, a builder, developer, and the very mention of that, you probably know where I'm going with this. She was persuaded by him to enter into a series of property transactions, swapping her property for a jointly owned property and raising money on mortgage. And there was a sequence of transactions, but latterly it ended up with the borrowing from One Savings Bank for about £384,000. Now, it went in as a joint application. That's the critical point. And as a result of that, a single solicitor acted for Miss Waller-Edwards, Mr. B and the bank. Now, critical to the whole transaction, of course, is what they told the bank. And what they actually told the bank on the application form, very roughly, readily on the figures, $200,000 required to pay off a previous mortgage, $40,000 to pay off Mr. B's debts, that's car finance, credit cards, and $142,000 to purchase another property jointly. In fact, the way the borrowing was actually used was that $234,000 was used to pay off the previous mortgage, and $142,000 was used to pay off B's wife on divorce. Now, that $142,000 works out, I think, at about 37%. Let's call it 40% in round figures. So in fact, a much bigger chunk being used to pay off B's ex-wife, borrowings for husband in this scenario. But of course, the bank didn't know that. I'll just go back to the last slide. That's what the bank knew. Just 40,000 or about 10% being used for husband's benefit. Now, as often happens, shortly after the transaction completed, the relationship breaks down. B moves out. He stops paying the mortgage. So following default, One Savings Bank commenced standard CPR 55 mortgage possession proceedings, which Miss Waller-Edwards defends on the grounds of undue influence. So, trial before a circuit judge in the county court, and he was able to make a finding of fact of presumed undue influence. That's a breach or an abuse of trust and confidence. But, and this is a key point, he held this was not a typical surety type case, the O'Brien case. It only had an element of surety. That's about the 10% borrowing that the bank was told was for him. The judge said it put the bank, whether it puts the bank on notice is a question of fact and degree, but at 10%, he said it fell on the pit side of the line. The bank wasn't put on notice, so of course the bank could enforce fully. It's Waller-Edwards appealed, and it goes to a first appeal before Mr. Justice Edwin Johnson. I've put the neutral citation up there. It's quite a full case note, actually. He considered the court's approach, specifically in these mixed or hybrid cases, whether there was in fact a distinct category, and said that how one identifies a partial surety case to which the O'Brien principles apply is a fact-sensitive question. So he agreed with the trial judge's overall assessment. It's a question of fact and degree. He agreed 10% wasn't enough. Miss Waller-Edwards appealed against that, contending that there was a hybrid category of cases, and specifically the lenders put on an inquiry unless the benefit to one of them is trivial. As a significance here, I guess, is this is a second appeal. It attracts slightly different permission to appeal criteria, CPR 52.7. The Court of Appeal will not give permission unless it considers that the appeal would have a real prospect of success and raise an important point of principle or practice. So Mr. Justice Lewison gave permission. He recognised there was at least an argument about whether there was a hybrid category of cases. But having assessed the merits of the appeal, he said no, the appeal was dismissed. There's no third category for hybrid cases. And significantly, it's the way the Court of Appeal analysed the arguments and ultimately agreed with the judges below. The court should look at the transaction as a whole and decide whether, as a matter of fact and degree, the loan's being made for husband's benefit as opposed to their joint benefit. So, I guess the assessment of which side of the line it falls on, whether it's the O'Brien engaging the Ettridge guidelines or Pitt, which doesn't, is a question of fact and degree. And of course, on those facts, the 10% known borrowing wasn't enough. So let's just try and review that now and see where it gets us, what the implications are, what it means for practitioners. I repeat, importantly, you look at this from the point of view of the lender. So what information does the lender have? Typically, the lender gets a mortgage application form in. It can see, on this case at least, it's a joint application but split purposes. So it then requires really a value judgment by the lender. So in a 10% case, which is the Waller-Edwards case, we know it's a question of fact and degree. The lender can probably treat it as a PIC case and not require to comply with the Ettridge guidelines. So it doesn't have to send a party off for independent legal advice. But the question I pose is, what if it's in fact, say, 20% or 30%, or as in fact happened in this case, about 40%? Now, at what point then does the lender conclude that it's not a joint loan and that it engages O'Brien and Ettridge? And of course, if you reach that conclusion at, say, 40%, which, as I say, is what actually happened in the case. So the lender ought to engage the Ettridge guidelines and send the wife off for independent legal advice. What do you do if it's 50-50? Who do you send off then? Or do the purposes cancel each other out and mean that overall the court can conclude it's a joint borrowing case? The problem is that those points weren't addressed in One Savings Bank. Those sorts of outcomes and implications weren't really identified or followed up. So what does it mean? Well, I think for lenders, I've just quoted quite an important, relevant observation of Mr. Justice Morgan back in 2013. Lenders aren't required to play detective. They're not required to make further inquiry, to go behind a mortgage application form and to double check where or how the borrowing is actually being applied. The problem is that when they get the mortgage application form in, which does show some more material element of borrowing just for husband, they will, I think, now be required to take real care when they get the form in. There's no third category in hybrid cases. We know that now from this decision, but the lender, I think, will have to exercise a value judgment on whether the borrowing falls on the O'Brien side or the Pitt side. Didn't have to do that in Waller Edwards. 10% didn't do it. But a greater percentage, I think, will cause some problems. So I do urge some caution by lenders. As I say, if they get this wrong, it may well unravel constructive notice of undue influence and the risk of challenge. And of course, once a lender is exposed to constructive notice, it's exposed to constructive notice of the full extent of the borrowing. So the 40% of the borrowing going to husband's benefit in this case. What are the implications for litigators? And I posed this right at the beginning. Litigators principally acting for wife in our analysis. Well, just again to be clear, we're dealing here with cases where there is a joint application, so ordinarily it will be treated as a Pitt case. The lender is aware there's a material element of the borrowing for husband's purposes. So, of course, I think those acting for wife need to fundamentally find out what information the lender was given. And it's a case where the lender hasn't followed the Ettridge guidelines. I think once you've got those three things in place, then there is some element of risk for the lender. And if, of course, litigators acting for wife can make out a credible case of undue influence, I think it may open the way to challenge. Of course, as always, do weigh outcomes, weigh up cost-benefit, and always bear in mind alternative remedies available to lender. I should just pause there, just mention one other thing that did occur in the Waller Edwards case. There was a separate point about imputing notice to a lender via the solicitor. Of course, if you recall, there was one solicitor acting for all three parties in this case, and it was alleged that, in fact, more information had been given to the solicitor than he'd passed on to the lender. So the argument was that there should be imputed notice under Section 199 Law of Property Act. Well, there was some analysis of that in the Waller Edwards case. The Court of Appeal referred to a previous case, Halifax Mortgage Services and Stepsky. It's a 1996 decision, and said, in effect, just read the note, Section 199 only extends imputed notice to knowledge of facts which come to the solicitor, as solicitor for the lender as such, and would not extend to facts and matters which come to the knowledge of the solicitor when acting for husband and wife. I think that's a point to bear in mind about getting over or getting past the solicitor who's acting. Just to wrap up, for more information on this, I've referred to my own legal information website, www.legalmortgage.co.uk. It's got a lot of commentary on the law. There's quite a bit to print off. A lot on forms, on practice and procedure, and in particular, there's a very useful monthly update section, so you can sign up to receive free monthly updates. And in fact, if you have a look at legalmortgage.co.uk, scroll across the banners at the top, you'll see Update 2024. If you go down to April 2024, the update has a full case note of Waller Edwards. It also has my full article on Waller Edwards. I should note as well, if you have access online through LexisNexis to Atkins Court Forms, have a look at volume 28.1 on mortgages. I completely rewrote that edition in 2020. It's got a lot on mortgage litigation generally, but quite a lot on undue influence. So there's some useful commentary in the initial section. And of course, there's quite a lot of precedents that I provided, claims, defences, replies as well. So quite a lot of information there if you want it. That's it from me. I said right at the beginning I'd put my email address up if you wanted it. Any questions I'll take by email. But that's it from me. Let's have a look at the time, 9:57. I'm just going to stop sharing. I hope that's been a useful run-through on undue influence. Next speaker is our brilliant Mark Harper KC. Quite an interesting topic, adverse possession, issues relating to Schedule 6. Mark's on in just about 10, 11, 12 minutes at 10 past 10. So do join us for that. But from me, thank you and goodbye.